How would I know about permitted development and whether I've got any rights?
So PD rights come from the General Permitted Development Order. So there were several different versions, iterations of that legislation, but that's where the phrase PD comes from, General Permitted Development Order. Permitted development rights are rights given to you by Parliament that bypass the local authority. So it's important from the outset to make sure that you do have those permitted development rights. And in many cases, in most cases, you do, but in a sizable minority of cases, you may not. So the easiest, most common way that permitted development rights have been removed is through a previous planning application that could have been made by a previous occupier of the dwelling 5, 10, 25 years ago. And that could have been for a seemingly unrelated application. It could have been for a loft conversion, and the council have deemed it necessary and fair to remove permitted development rights for outbuildings. And that probably could have been considered to be reasonable at the time, because at the time you had a volume-based, many years ago prior to 2008, you had a volume-based permitted development allowance. So the council considered that if you've used your allowance on your loft, then you wouldn't be able to, it wouldn't be fair or reasonable to have large extensions. That all changed many years ago, but that's quite a commonly held misapprehension of the regulations, that this volume-based is shared between the classes. That's not the case. Each type of development is for permitted development is broken down into classes. So Class A is extensions. Class E, which we're talking about today mainly, is outbuildings. Class C is roof alterations. And where you can actually maximise each of those different classes, it's important to say that they're mutually exclusive. So you could completely max out your loft conversion rights, let's say, but that would leave all of your rights for extensions intact. So back to your original question, how do you know whether you have your PD rights intact? You can look on an old planning permission, and it's important to look at your full history, because the permission in question could have been back from the 1960s or 50s. And the other way that permitted development rights are removed is through the general outline permission for your whole estate. So if you're living on a reasonably modern estate of 5, 10, 15 years old, that could have been sort of optimised by the developer already. And in recognising that, the council could have removed permitted development rights for further extensions and alterations to take place, because they consider that the plots have been filled, if you like, already, and any further encroachment into garden space would have detrimental potential impact on your enjoyment of your house by you erecting an extension that might be 3 or 4 metres deep into a garden that's only 7 or 8 metres deep. So you can see there are all sorts of reasons why PD rights are removed, and also many properties don't have them in the first place. Masonettes, so a ground floor flat, or any flat for that matter. Any converted dwellings, for example, a Class Q barn conversion doesn't have any PD rights. Another example are listed buildings. Buildings in conservation areas have eroded rights. So don't just make the assumption. It's always better to take professional advice and answer the question. And some of those answers could come from the council themselves, and some could come from a chartered planning consultant, for example.
New Garden Room Company. More space for your life.